Hi, everybody. I really enjoy introducing speakers. It's something I've come to really take a lot of pleasure in since I've been here at the University of Mississippi. I'm a big believer that you should be able to do this in under 90 seconds so you can get the star up here and they can shine, but that also that you give them their flowers, especially when they're due, as is this case. It is my great pleasure and honor to introduce Jade Craig, who is an assistant professor at the University of Mississippi School of Law. Jade teaches political and civil rights, constitutional law, real estate law, and fair housing law. In addition to all of the great things he does in the classroom, he also just has an incredible background. So in 2014, the Obama administration appointed Jade Craig as a special policy advisor to the Assistant Secretary in the Office of Fair Housing and Equal Opportunity at the U.S. Department of Housing and Urban Development, or HUD as we know it. And then I have had the great pleasure myself of collaborating and working with Jade on some community engaged and community-based events since Jade has been here, and he's just a wonderful person to collaborate with. He gives 100% in everything that he does, and he's as sharp as they come. So I'm so excited for this talk and so excited to turn this over to you, and I told you under 90 seconds.
There you go. Thank you. Well, thank you, JT, for the marvelous introduction and for all of your work leading this collaboration around community engagement and housing in the Oxford Lafayette University community. I'm really excited to be here to give this talk, especially given the focus of this center and its work in the South and the importance of thinking about the regional connections with racial zoning, land use policy, and the unique structure of racial segregation in the South. So this presentation arises out of my first law review article, which was published in the Mississippi College Law Review in 2022. The title of the presentation, Pigs in the Parlor, comes from a line in the Supreme Court's majority opinion in Village of Euclid, Ohio versus Ambler Realty Company, a case decided in 1926, which approved the power of local governments to engage in municipal zoning. The court held that zoning ordinances were a permissible exercise of the state's power to regulate the use of land for the health, safety, and welfare of the general public. Since local governments are created by state governments, that power also extends to them. So writing for the court, Justice George Sutherland explained, a nuisance may be merely a right thing in the wrong place, like a pig in the parlor instead of the barnyard. The court allowed for the exclusion of certain trades that could create a nuisance, whether it be a factory, a construction company, or a house of prostitution, from certain districts, specifically neighborhoods set aside for single-family houses. The usual 2 or 3 bedroom bungalow, ranch-style house, or 2-story house that we're all used to seeing on tree-lined streets in comfortable areas. This vision of the American dream, starting with the single-family home. The court also upheld the ordinance's decision to keep apartment houses out of certain neighborhoods. The court explained that cities should have the power to keep apartments out of single-family neighborhoods because they are often, quote-unquote, a mere parasite constructed in order to take advantage of the open spaces and attractive surroundings created by the residential character of the district. One apartment house is followed by others, interfering with their height and bulk with the free circulation of air and monopolizing the rays of the sun, which would otherwise fall on single-family houses, which tend to be smaller. Apartment houses, according to the court, bring traffic and deprive children of the privilege of quiet and open spaces for play. And ultimately, they, in the words of the court, utterly destroy the residential neighborhood. The court admits that apartment buildings in a different environment would be not only entirely unobjectionable, but highly desirable. But they come very near to being nuisances in neighborhoods for single-family houses. I taught this case in property, one of the 6 required first-year law school courses that I've taught before, and I had to ask the class, with this language of parasites and nuisances monopolizing the rays of the sun, are we still talking about apartment buildings, or are we talking about people? People live in these apartment buildings. According to the National League of Cities in 2023, black households make up 12% of all households, but make up 27% of renters earning less than $15,000 a year. Black households are also overrepresented in the rental market generally, with 58% of black households renting their housing compared to 28% of white households, the highest of all racial groups in the United States at 58% as renters. Are black people parasites in white neighborhoods, which make up the bulk of areas with single-family houses? Don't black children deserve quiet and open spaces to play? Don't black people deserve to live in truly residential neighborhoods? Don't they deserve the free circulation of air and to share in the rays of the sun like everybody else? So I've researched the racial zoning movement. And I first became interested in understanding racial zoning when I took a course on land use law as a law student at Columbia University. After one of the cases in the textbook, there was a reference tucked away in the notes about a series of local laws that literally provided that black people could only live in these areas and white people had to live in separate areas, certain city blocks for blacks and certain blocks for whites. And that these were in cities all over the South, starting in Baltimore, Maryland in 1910. And this is part of the reason why I always encourage students to read the notes after the cases in the textbook. Because I said to myself, what? How could this be? I couldn't believe that segregation had been this explicit in America, despite all the knowledge and the time that I spent reading about race and the civil rights movement in the United States. The Supreme Court struck down this practice in 1917 in a case called Buchanan versus Worley, which is part of the reason I suppose that the authors have put it in the back and the notes of the textbook. But this movement reconfigured itself in the zoning laws approved by the Supreme Court in the 1920s. The racial zoning movement and its aftermath suggests that black people have long been associated with nuisances. Under the facially neutral zoning rules approved by the Supreme Court, they fit into the symbology of other land uses that were not just excluded from white communities, but which came to serve as markers of black communities and blackness, which non-black people were taught to avoid. Zoning implicates the age-old question posed by W.E.B. Du Bois, arguably the father of American sociology, and his seminal work, The Souls of Black Folk. How does it feel to be a problem? Zoning has from its origins been used to treat black people as a problem. Within the logic of the Supreme Court's metaphor, land use law has often regarded African Americans as the proverbial pigs in the parlor. African Americans were metaphorically right things, sort of a Dr. Seuss style phrase. Efforts to remove black people and their racialized cultural practices have avoided the presumption that black people do not have a right to exist. Indeed, the earliest cases in which white plaintiffs in southern and border U.S. states attempted to stop black cultural practices, like an effort to remove a black Protestant church that had loud worship services from their neighborhood, or to remove blackness from their presence altogether, under the law of nuisance, generally failed. The first strategy at sort of removing black people from white spaces were to bring lawsuits claiming that black people posed a nuisance in violation of tort law, but many of those cases failed. Black people have some legal right to exist, according to the courts, but zoning laws did what nuisance law couldn't do. It allows cities to create rules that communicated openly at first with racial zoning and then in racially coded ways that black people belong over there and not here with us. And the white majority doesn't belong over there with them, which fuels the racially segregated society that the Fair Housing Act of 1968 was intended to radically eliminate. My article focuses on the South, where racial zoning became the predominant method of ensuring racial segregation in housing and excluding African Americans from white communities. And I believe it's important to examine the South to understand the structure of racial segregation and the role of land use policy more closely. Social scientists, including geographers, have acknowledged that racial segregation in housing that revolves around which groups live on high ground or low-lying areas takes place across the United States. The South is unique, however, because of its history of slavery, the high population of African Americans, and this fraught political climate, which is heavily polarized along racial lines. Small towns and rural areas are also spaces that generally escape study and fair housing legal scholarship. The focus is often on big cities, and fair housing policy fails to create rules that capture the structure of segregation outside of these areas, including in rural communities. While the U.S. Supreme Court struck down the practice of racial zoning in 1917, the practice continued for many decades thereafter, either directly or in thinly veiled forms, at least in part because of the historical durability and unique character of Southern race relationships. I argue that racial zoning was more than a tragic moment in time that ended with the court decision striking it down. Instead, I examine the legacy of racial zoning. This legacy includes the blueprint for racial segregation and that these ordinances created and that segregated living patterns remain as a result of these ordinances. It also includes the groundwork that these ordinances laid, which informed land use policy toward black communities going forward, even after high courts formally stripped local governments of the authority to pass these kinds of ordinances. This focus on the South is important because space and racial hierarchy often interacted differently in this region than they did in other parts of the country. A 20th century African American saying encapsulates this difference. The South doesn't care how close a Negro gets, just as long as he doesn't get too high. The North doesn't care how high he gets, just as long as he doesn't get too close. This folk wisdom draws on the experience of African American migrants who left racially zoned towns to find freedom in the North and West Coast during the Great Migration around World War I in the 1910s and then World War II in the 1940s and early 1950s. The height of these first and second waves of the Great Migration, and civil rights leaders who took the Southern organizing campaign northward. For northern and western U.S. cities, geographic segregation between the races played a crucial role in excluding African Americans from the institutional forms of power and resources amassed by whites in majority white areas. Northern and western U.S. cities often relied heavily on race-based restrictions and deeds, blocking the sale of property to people of color, and housing discrimination. By contrast, African Americans and whites in the South historically lived in close proximity to one another. So the early efforts at establishing white supremacy and racial hierarchy began by designating spaces for blacks, sometimes with only railroad tracks as barriers, rather than the long highways that emerged shortly after the second wave of the Great Migration in the post-war period of the 1940s and 1950s. The history for the conditions that led to racial zoning goes back to the period after the Civil War, starting with the 1860s. When a Union military general asked a group of black Southerners in Augusta, Georgia, shortly after the end of the Civil War, what he should tell Northerners who asked about the status of blacks in the South, Richard Robert Wright Sr., a black intellectual and one of the early educators of the black community in Augusta after the Civil War, shouted, "Tell them we're rising." And it was this rise that many white Southerners worked tirelessly to put down. Reconstruction, a time of rising black equality in the South that faced constant white backlash, ran from 1865 to 1877. And its end led to a profound social upheaval as white Southerners returned to power at the same time that the number of African Americans migrating from rural to urban areas in the South increased significantly. Black populations in major Southern cities rose by 10 to 15% from 1860 to 1910. In 1860, only 3 Southern cities, Jacksonville, Florida, Norfolk, Virginia, and Richmond, Virginia, had a black population that exceeded 25%. By 1910, the number of cities had risen from 3 to 10, the same year that Baltimore passed the nation's first racial zoning ordinance targeting black residents. So while Baltimore's ordinance was the first racial zoning ordinance designed to pass the separate but equal test that the court approved in Plessy versus Ferguson in 1896, which legalized Jim Crow segregation, the earliest racial segregation ordinance appears to have been the Bingham Ordinance in 1890, which prohibited people of Chinese descent from living or doing business within San Francisco County, except in a small district prescribed for their location, as the ordinance said. limiting the homes they could live in to certain geographic areas. It was, however, struck down by a federal trial court in California that same year. But it reconfigured itself into land use policies that discriminated against Asian Americans, a long disfavored racial minority group in the West. The Baltimore strategy, however, held on for longer. The segregation ordinance in Baltimore also developed as a direct response to prevent racial integration. During the summer of 1910, George McMechen, a Yale Law School graduate and a practicing attorney, an African American, moved with his wife and children from their former home, which was only 10 blocks away, to a new house. But in that move, he crossed the color line in northwest Baltimore when he moved from an affluent black section into a home in a fashionable white neighborhood in the city. The move immediately provoked agitation, and his family faced harassment. By December 1910, from the summer when he moved to Christmas, after months of protests from black residents, the city passed its racial zoning ordinance, which provided that no Negro can move into a block in which more than half of the residents are white, and vice versa for whites, or they would have to pay a $100 fine or be subject to up to a year in jail. In Baltimore and beyond, in the South and border states, the increase in the number of black residents alarmed whites in these cities, leading to race riots and massacres of black residents in Atlanta, Houston, Winston-Salem, North Carolina, Washington, D.C., and Tulsa, Oklahoma, probably the most famous today of these race massacres. In 1915, the Court of Appeals of Kentucky justified Louisville's racial zoning ordinance by pointing to the gravity of the race problem as it exists in our country today and congested municipal conditions. The interest in preventing racial conflict likewise shows up in other cases upholding racial zoning ordinances by state high courts in the South during this time period. Louisville would become arguably the most notable convert to the movement to establish what historian David Delaney has called municipal apartheid, because its law led to the movement's formal end. The end of the official racial zoning ordinance came with the creation of a test case, a brilliant move of legal strategy. The facts of Buchanan versus Worley were set up to turn the expectations of the civil rights litigation style on its head. You would think that the challenger would be a black person who couldn't move into a home on a white block, who argued that the law violated his right to equal treatment regardless of race. But civil rights activists knew that the court that had legalized Jim Crow wouldn't care about that. Instead, they found a white plaintiff who would lose if the racial zoning ordinance was upheld, to put the Supreme Court between a rock and a hard place, preserving racial zoning or the supremacy of white economic power. In the case that ultimately reached the Supreme Court, Charles Buchanan was a white realtor who entered into a contract to sell his property to William Worley, a black postal worker. But the contract included an escape clause that Worley would not be required to pay unless he was allowed by law to live on the property. Buchanan, the white plaintiff, sued Worley for a specific performance, which is a legal remedy that allows the court to order that a contract for the sale of land be performed and requires the party who refuses to complete the transaction to complete it. Worley raised the racial zoning ordinance as a defense. So the white person sues the black person. He raises the racial zoning ordinance as a defense to why he can't perform under the contract. Worley argued that he couldn't perform because the property was in a whites-only area and the ordinance prevented him from taking possession because he was black. The Supreme Court ruled that the ordinance violated the 14th Amendment, which includes the right to acquire, enjoy, and dispose of property, in the words of the court, because it restricted the right of property owners to sell their property on the basis of race. The decision ostensibly benefited black land buyers, but it came in terms of a win for Buchanan, the white seller. The white seller wins and the black prospective buyer loses. The court found that he could not be denied the right to sell his property to whomever he pleased. It is true that state high courts and the Supreme Court did summarily reject several iterations of zoning ordinances based on the authority in Buchanan alone shortly after they were passed. Atlanta's zoning ordinance went all the way to the Supreme Court and was summarily struck down. New Orleans had a similar zoning ordinance that was struck down in 1927, purely based on Buchanan. The foundation of the reasoning in Buchanan, however, worked like a poison pill, limiting the anti-racist implications of the ruling from the start. It did not undermine the architecture of segregation. It did not prevent the racializing of spaces as black and denigrating them with undesirable land uses and hazardous conditions, while at the same time elevating the protection afforded to white spaces. While Buchanan had some success in removing this explicit barrier to entry in a white neighborhood, the end of explicit racial zoning did not keep white city government leaders from denying public services to black neighborhoods. In the Euclid case from 1926, the court affirmed this nuisance view of zoning, but did nothing to counter the idea that people being labeled as nuisances. Namely, blacks affected by discriminatory racial zoning practices or policies. The irony of the reference to nuisances as pigs is that Baltimore, the first city to pass a racial zoning ordinance, maintained a black community that it referred to as Pigtown. Between 1880 and 1900, Baltimore's black population increased by almost half, from 54,000 to 79,000. Blacks arrived in Baltimore with little money and very few job opportunities. Many of them rented small shacks, often with 2 families to a house, in order to pay the rent, creating Baltimore's first sizable slum. And this community had to live alongside the area near the Baltimore and Ohio Railroad, featured in the game Monopoly, B&O Railroad, as you might recall, which released the pigs that it transported for slaughter into this neighborhood, which is why the area was called Pigtown. Buchanan's failure to outlaw state-imposed racial segregation in housing left the door open for cities and towns to reproduce the same inequalities through different policies that would achieve the same goals, policy goals of racial segregation and white supremacy. While racial discrimination in housing nationally focused on private market forces and federal housing policy, the South faced these same challenges and placed more emphasis on the abuse of zoning rules and anti-black land use policies. Urban planning historians explain that the South's pattern developed differently as a result of lower residential density and wider spatial dispersion of black neighborhoods across the city. Local governments have kept exclusionary zoning ordinances, land use regulations, and local investment strategies in their larger political repertoire to impede the full participation of rural minorities. The legacy of racial zoning also indicates that these urban development policies limited access to housing, social mobility, and economic development for black communities. Court challenges to policies in housing and public services that disadvantage African Americans testify to the legacy of racial discrimination in land use and the effect that it continues to have on black communities even after the end of legalized segregation in the South. As late as 1950, the Texas legislature conferred upon cities the power to separate residential areas on the basis of race, and the law remained on the books until 1969. More than 40 years after the state legislature, more than 40 years before the Texas legislature explicitly authorized municipalities to pass laws enforcing residential segregation, the charter for the city of Dallas, issued in 1907, expressly gave the city the power to require complete racial separation, including, quote unquote, the use of separate blocks for residences. So the city charter was very similar in terms of authorizing the city council to pass what would amount to a racial zoning ordinance that limited people of color to certain blocks and whites to other blocks. Dallas continued to enforce its race-restrictive laws and did not repeal that portion of the city charter until 1968. 20 years later, the city admitted in litigation that its racial zoning laws had established racially segregated housing patterns that had not yet been fully eradicated, even though the city had stopped considering race, according to its claims in the litigation, in providing housing. In Florida, an ordinance prohibiting racial intermingling, quote unquote, dated back to 1914, but it remained on the books until 1975. And the court recognized that the ordinance contributed to the pattern of blacks living on, quote, the other side of the tracks in a lawsuit involving Dade City, Florida. In Miami, the county passed a racial zoning ordinance in 1945, along with its laws segregating beaches, like many counties in Florida which had segregated beaches. The ordinance limited black residents to areas that were already majority black, including an area now called Overtown, but which was originally called Colored Town in central Miami. A black couple was arrested and charged with the crime of living in the wrong area in State versus Wilson in 1945, and the Florida Supreme Court struck down the ordinance. These residential patterns, however, leave physical reminders of the legacy of Jim Crow and shape the context and limits of community development and affordable housing in the South. As historian David Delaney also explains, the history of race relations in the United States has been the history of conflict over spatial relations. The geographies that we all live in tell the tale. The anti-black land use policies that developed during and after Buchanan reflected the same background principle expressed in racial zoning. Blacks were considered nuisances that could be relegated to communities among other undesirable land uses and excluded from the larger social and economic structure of the towns and cities in which they lived. The legacy of racial zoning that follows Buchanan and Euclid revolves around a process of confinement and degradation. Cities use zoning laws to confine African Americans into certain areas. This confinement facilitated the degradation of these communities. The article, my first law review article, highlights three major policies. First, the location of black communities in the least desirable areas. Secondly, the lack of protective zoning afforded to black communities. And third, the disproportionate siting of locally undesirable land uses, sometimes referred to as LULUs, in or near majority black communities. These three policies came together to reinforce white supremacy by racializing black spaces, identifying them as degraded and unlivable. The confinement of black residents into particular areas also included decisions, often included decisions to designate the most undesirable locations with built-in environmental risks and disadvantages for black occupancy. In the early years after the Civil War, the process of limiting access took place largely through private discrimination. Even in our own state, Isaiah T. Montgomery, the founder of Mound Bayou, Mississippi, and the only African-American delegate at the Constitutional Convention of 1890, which stripped African Americans of their civil and political rights until the passage of federal laws in the 1960s, was sold land by a railway company in a section of the Mississippi Delta that was the home of the mosquito, periodic floods, wild animals, and fever, where no person had previously been induced to settle, according to Norman Crockett's account in the book Black Towns. The land commissioner for the railroad had tried convincing white farmers to settle in this area, but because of these conditions, he began focusing on targeting black farmers because he believed they were immune to the diseases of the Delta and unaffected by the high humidity and intense heat. I will say I lived in Greenville in the Delta for 3 years in Teach for America, and I was not immune to the high intense heat and the mosquitoes, but it was, a good work for the cause, so it was worth it. In 1865, a group of freed slaves in North Carolina established the settlement of Freedom Hill, which is believed to be the oldest town charted by formerly enslaved people in the United States. Freedom Hill was later incorporated as Princeville in honor of its founder in 1885. The town, however, was situated on marshes and swampland along the Tar River in eastern North Carolina. For Princeville's early black settlers, their existence in this space was not a matter of chance or of choice, but instead the discarded and unwanted space that former slaveholders allowed them to occupy. With zoning, local governments used land use law to designate the most undesirable land for black communities, not just by private discrimination, but by law. In 1926, the city of Birmingham, Alabama adopted an ordinance that created specific residential districts designated for blacks and others designated for whites. And yes, this did happen almost 10 years after the Supreme Court said no, that wasn't allowed in 1917. But just because the court says it's not allowed doesn't mean people don't continue doing it. Starting in the latter part of the 19th century, many African Americans in Washington, D.C. were relegated to living near the dirty and polluted banks of the Anacostia River. After World War II, the federal government, which controlled D.C. before it received home rule in the 1970s, built a public housing project for black residents near this area, which reinforced racial segregation in the nation's capital. During the same time period of the 1940s, the city of Dallas developed plans to locate a segregated African-American community known as Cadillac Heights in an area that it knew was a floodplain. And the result has followed the residents of South Dallas to this day in this area with constant flooding. Birmingham forced black labor to live in the city's vacant spaces near creeks and railroads where whites did not wish to live, a set of conditions which ultimately set the stage for the civil rights struggle that took hold throughout the mid-20th century. Birmingham also used federal highway construction funds to relocate blacks to less desirable locations. Interstate 59 divided the black community of Inslee from the white section known as Inslee Highlands, a name which suggests its elevated status in a region where blacks often occupied low-lying sections of the inner city, and whites who increasingly moved to the suburbs built their homes in the highlands. In this way, local governments in the South used the power to control options for black residency to force communities of color to bear a disproportionate share of the environmental harms. And these land use policies have come back to haunt black communities in the present. From 1865 to 1958, there were 6 documented floods in the Tar-Pamlico River Basin, where Princeville is located. The town's historical outreach coordinator claims that parts of the town have been flooded at least 24 times since 1870. Hurricanes have inundated this town with water, most recently Hurricane Floyd in 1999, and then Hurricane Matthew in 2016. After Hurricane Floyd, which was billed in this area as the flood of the century, a once-in-a-lifetime event that residents thought would never happen again, nearly every home was damaged. Some parts of the town were more than 20 feet underwater. A 2016 New York Times article reported that many of the town's 2,100 residents, after Hurricane Matthew came through that year, 96% of whom were black, were considering whether to sell their land, which would devastate the town's tax base, because they were struggling to rebuild after constant flooding. Sure enough, the 2020 census put the town's population at 1,254, a steep decline from 2010, where they were at over 2,100 residents. In 1925, the year before Birmingham passed its own racial zoning ordinance, the famous designers of New York City's Central Park proposed a grand park on the banks of Birmingham's Village Creek. The park would accommodate consistent flooding on the banks of the creek, of which the city was aware. Yet under the racial zoning ordinance passed the following year, the city chose to scrap the plan for this beautiful grand park designed by the builders of Central Park in New York and zoned that land for black occupancy. As a result, many black neighborhoods struggled with flooding problems for decades. It was not until the 1990s that the city, with the help of the federal government, began to undo the mistakes of the past and converted some of the substandard housing in neighborhoods along Village Creek to parkland. The result of the federal government's intervention provides an example of how transformation can be made that both benefits black residents and furthers economic development for communities as a whole. An awareness of the historical role of discriminatory land use policies in limiting access to fair housing and a refocusing on urban development as part of this duty to affirmatively further fair housing, a little known and underused provision of the Fair Housing Act, which can make these kinds of opportunities more identifiable. The reliance on cumulative zoning in the early years of zoning's popularity resulted in the industrial zone becoming a garbage pail for all uses, including residences. The argument was that if a home was located in a garbage pail district, the misguided or unfortunate person had only himself to blame. In a city that applied a racial zoning ordinance or policies that grew out of one, the assignment of a black racial district to an area shared with industrial and commercial uses was not a matter of the buyer's poor decision making. These policies enshrined racial hierarchies into law. While the literature is often focused on efforts to maintain white spatial exclusivity and the privileging of white space, explosive zoning and the failure to provide protective zoning are both part of the process of inscribing black residential areas with features that seek to render them undesirable spaces of disadvantage, and that particular pattern has received less attention. Just as city leaders selected locations for white communities in the most desirable sections of a city and used land use law to protect people from undesirable land uses. They often assigned African Americans to the least desirable areas of town. They refused to protect black communities with zoning laws and made them available to host undesirable but necessary land uses like landfills and factories over and above their fair share and to the benefit of white communities. The lack of protective zoning disincentivizes the building of mixed-income housing in these communities, something that furthers segregation and violates a local government's duty to affirmatively further fair housing under federal law. While high-end amenities in white communities often attract whites while disproportionately excluding people of color, these features of black communities keep people out. Tennis courts attract while factories repel. But they both shape choices about living in certain kinds of communities. As a white South African legislator explained to the parliament that maintained apartheid in justifying the Group Areas Act of 1950, he said, "It is quite simple. As soon as there is a group area, then all your uncertainties are removed, and that is, after all, the primary purpose of this bill." The Group Areas Act that codified apartheid as part of a whole constellation of laws in South Africa. This logic reflects the power of confinement in maintaining white supremacy and racial subordination. Cities use facially neutral zoning laws after Euclid in pernicious, race-conscious ways well into the mid-20th century. These laws played a critical role in achieving the goal of excluding African Americans from white neighborhoods. But just as important, however, is that zoning laws serve to confine African Americans into their own separate neighborhoods. As law professor Elise Body has argued, segregation further limited black mobility and spatialized racial power in public and private spaces. This confinement facilitated the degradation of these spaces as part of a long-term project to racially code them as black, in opposition to protected white space. The current environmental regulatory regime does little to undo the disproportionate siting of undesirable land uses like factories in black communities throughout the South. Instead, it further entrenches the impact of these past decisions. Several environmental laws providing for the so-called grandfathering of facilities that operated prior to the enactment of the Clean Air Act in the early 1970s protects them from substantive regulation. So, for example, the grandfathering provision of the Clean Air Act has had the most significant impact on black communities because the dirtiest facilities that emit the highest amounts of pollution were constructed prior to the passage of the federal law in the 1970s, disproportionately in black communities. To make matters worse, federal and state governments have yielded the real authority over where third parties can site the most polluting factories to local governments. The opportunity for a local government to take advantage of these conditions that they've already built through the historical legacy of racial zoning is high. Congress's intention in passing the Fair Housing Act was to provide within constitutional limitations for fair housing throughout the United States. Broadly speaking, the FHA prohibits discrimination in the sale, rental, or financing of dwellings on the basis of all of these protected classes. Courts, however, have made clear that the act prohibits both direct discrimination and practices with significant discriminatory effects on the availability of housing. Several scholars have argued that fair housing law relies on two core principles: anti-discrimination and anti-segregation. We know a lot about anti-discrimination in terms of filing a lawsuit against someone who engages in an individual bad act of housing discrimination, but not about anti-segregation, the goal of undoing patterns of racial segregation throughout the country. Litigation is powerful because judicial remedies can work to disrupt institutional arrangements by challenging structures and institutional norms and government decision-making. These remedies, however, in the context of the environmental results of racist location decisions for black communities, the failure to provide protective zoning, and the disproportionate siting of Lulus are limited. Several courts have barred post-acquisition habitability claims, basically a claim that arises after a person buys the house or moves in ways that can limit legal theories that involve neighborhood conditions. So, for example, in a case set in Dallas, which involved allegations that a landfill was deliberately placed in a black neighborhood and the city refused to remedy illegal dumping and mining, despite doing so for sites located in white areas, the plaintiffs argued that certain HUD regulations implementing the Fair Housing Act prohibits otherwise making housing unavailable and refusing to provide municipal services. But the federal trial court agreed with the city that the plaintiff's claim under Section 3604A on the ground that the provisions of ban of discriminatory practices that make unavailable or deny housing does not cover homeowners who seek to protect intangible interests in already owned property, such as the property's habitability or its value. The Section 3604B claim failed because the federal trial court interpreted this provision to apply only to discrimination in the provision of services that prevents the sale or rental of housing. And plaintiffs and the court found that the plaintiffs had not alleged discrimination related to the acquisition of their homes. So the court narrowly interpreted the statute so that you could only file a claim if you were prevented from acquiring a house rather than being subject to discriminatory terms and conditions once you've acquired or started living in the house. Likewise, while discriminatory provisions of municipal services claims have often succeeded, like claims against the city that refuses to provide water, sewer, or trash service in majority-minority communities, cases involving siting decisions for land uses that detrimentally affect the residential character of a neighborhood have often failed. Advocacy groups filing lawsuits in court and at HUD have attempted in recent years to enforce the mandate that all federal agencies involved in housing and recipients of HUD funds, including state and local governments, must take steps to affirmatively further fair housing, which is a provision of the Fair Housing Act at Section 3608. And not just to prevent discrimination, but to pursue what the senator who introduced the Fair Housing Act to Congress called integrated and balanced living patterns. But with each administration, Democratic presidents like Obama and Biden have issued a regulation to enforce the mandate. And in full disclosure, I was part of the team that helped to issue the AFFH rule in 2015 as an appointee in the Obama administration. And the Trump administration has repealed those rules now twice. Once in 2016 and then in 2024 when the Trump administration came back a second time. Still, given that it can this obligation can still be enforced in court through a claim that a grantee has falsely certified to the federal government that they are furthering fair housing, basically amounting to fraud against the government when they're not furthering fair housing. The AFFH mandate is still potentially a step in the right direction for rethinking the meaning of fair housing more broadly. It has become central to reviving the anti-segregation interest in fair housing. It also allows these problems to be addressed by requiring local governments to adopt policies that address disparities that grow out of the legacy of racial zoning. The Community Development Block Grant is perhaps one of the most important sources of leverage. Jurisdictions around the country receive millions of dollars in HUD funds and are required to comply with the AFFH mandate as a condition of receiving these funds. The process of certifying compliance, however, is left to the main agency that receives the funds. In large cities, the city receives the funds, but in rural areas, particularly in Mississippi, the state receives HUD funds and distributes them to cities. Jackson is the only sort of urban entitlement district in the state, and the rest of the state that receives HUD funds receives them through a state agency. The state agency certifies that all these local jurisdictions comply with the obligation to affirmatively further fair housing, but they don't actually verify, and the local jurisdiction isn't having to certify compliance itself. And this allows small town segregation to fall through the cracks. And I'd like to go to just a close with a hometown example. In a state with extremely high poverty rates, Madison, Mississippi has a 3% poverty rate. It has a home ownership rate of nearly 100%. The only census tracts in the state to fit this description are in Madison. In a state with the largest population of African Americans of any U.S. state in the country at 38%, Madison is about 10% black and more than 85% white. Madison has managed to maintain strong incentives to building, disincentives to building multifamily housing, apartment buildings, with an ordinance that requires landlords to pay a $10,000 bond for every unit of apartment housing that they lease. So if you have a 10-unit apartment building in Madison, the landlord is paying a $100,000 bond on leasing all of those units, which thoroughly, of course, discourages landlords from leasing and keeps apartments out, making less space for lower-income people and people of color in this wealthy jurisdiction. The ordinance, however, has apparently gone unchallenged by HUD and does not show up in previous fair housing analyses that Mississippi has submitted to the federal government, despite the state's likely awareness of it. Madison brings us back to the beginning with local land use restrictions that keep out black residents surrounded by communities in our state filled with undesirable land uses and hazards that keep higher income white residents from coming in. The apartment buildings in Madison have again been coded as the pigs in the parlor that the court tried to eliminate in Euclid. And so with that, I'll thank you. And here's a QR code with a link to my paper. Yes, JT.
Thanks so much, Jade. This was just really, really great. My question is really rooted in something you said at the beginning about how looking at racial zoning in the South gives us an opportunity to step outside of sort of the predominance of analyses that focus on major metropolitan areas, give a little bit more attention to rural spaces. I wonder if you can say a little bit more about how this works in those rural spaces, because a lot of the examples here are still kind of rooted in medium to large size cities. I'm thinking of Louisville, I'm thinking of New Orleans, which was mentioned, even Madison is sort of this kind of exurb of the Jackson metro area.
Mm-hmm.
What about kind of more traditionally rural spaces, of which there are just a ton all across the region?
Well, I would say that this pattern exists in those same kinds of rural spaces, but on a smaller scale. So the paper discusses Indianola, Mississippi as an example, which has this history of black residents who live on one side of the tracks and white residents who live on another. And so these railroad tracks still separate and segregate even small towns in terms of racial, sort of the racialization of space. And black communities are confined to a particular set of areas where they've historically been present and always, existed. And as part of that pattern, undesirable land uses have been sort of relegated to or sent to these same neighborhoods, which is why you see patterns of landfills, factories, or any kind of industrial development that residential neighborhoods typically want to avoid going into these areas, but amenities that people want to maintain, attract, or use, like the new shopping mall or retail center, goes away from that particular area. So there's still the same kind of coding that happens in small towns, just on a smaller scale. Thank you all so much for coming. Thank you.